Thank you. All right. Just as a matter of good order, the tribunal, you know, will feel free to interrupt you at any time, so you should not consider that we're being discourteous. This is our way of showing that we're listening attentively. So I believe that the first speaker on jurisdiction will be Ms. Svandova? No, I'm sorry, it'll be Ms. Oh, I'm sorry, excuse me, it'll be Mr. Jain.
Yes, Mr. President.
Mr. Jain, sorry. Mr. Jain.
Mr. President, members of the tribunal, a very good afternoon. Let me first introduce my colleague. To my left is Aditya Mehta, and I am Prakshal Jain, and together we will be representing the respondent, the Republic of Mercuria, in this matter. In the next 18 minutes of my time before this tribunal, I will be addressing two issues. First, that the claimant has been denied the benefits of the Bashira Mercuria BIT by virtue of respondent's invocation of the denial of benefits clause. And second, that this tribunal does not enjoy jurisdiction over any claims arising in relation to the contentious arbitral award. Beginning with the first issue, members of the tribunal, the respondent, in its response to the notice of arbitration dated 26th of November, invoked the denial of benefits clause in the Mercuria Bashira BIT. We submit that invocation of this clause denies them the benefits of the agreement because, first, we invoked the clause in the correct manner, and second, that the substantive requirements of the clause are satisfied. Addressing the first one, members of the tribunal, this arbitration is being conducted under the rules of the Permanent Court of Arbitration. Article 23, Clause 2 of the rules of the Permanent Court of Arbitration provides that any objection to jurisdiction must be raised no later than in the statement of defense by the respondent. In the instant case, the denial of benefits clause denies the respondent, if invoked correctly, denies the respondent of all advantages under the agreement. One of the advantages under the agreement is to have recourse to arbitration, which means that the denial of benefits clause, if correctly invoked, denies this tribunal of its jurisdiction and therefore constitutes a jurisdictional objection.
Counsel, if the tribunal finds that the applicable bit has a denial of benefits clause that's only prospective, not retroactive, do the PCA rules, Article 23, take precedent over the bit, or does the bit govern?
Madam Arbitrator, if the tribunal were to find in such case, then it will have only prospective application. However, it is our submission that a denial of benefits clause should be applied retrospectively. This is because the very reason a denial of benefits clause exists in a treaty, as was held by the tribunal in GAI versus Bolivia, is to give the respondent an opportunity to deny benefits to the investor when the investor makes such a claim. And therefore, it would be appropriate to have retrospective application of the denial of benefits clause to claims that have arisen before its invocation.
But counsel, the respondent has had notice of this dispute for weeks before the request for arbitration was actually filed. Shouldn't the respondent have said something then?
Madam Arbitrator, as soon as they provided their notice of arbitration, the next logical step is our response to notice of arbitration. That was the first opportunity that we had after them raising the dispute to raise our objection. In that response itself, dated the 26th of November, we did raise that objection, which is in consonance with the PCA rules, as well as the general ruling over the fact, the general proposition over the fact that it should have retrospective application and not merely apply prospectively. Does that answer your question, Madam Arbitrator?
Yes.
Thank you.
Which one of you will be getting to the point that you alluded to about the award not being an investment?
I will be dealing with that, Mr. President, after I submit that the substantive requirements of the denial of benefits clause are also satisfied.
We
Would you
don't
want
want
me to
we
address
don't want
that?
to miss the time for that, because that's a vital issue, isn't it?
Certainly. Would you want me to address that first, Mr.
Well, if you can address the other questions quickly
Yes.
and then get on to that.
Certainly. Now, the second submission that I have is that the substantive requirements of Article 2, Clause 1 are also satisfied. Article 2, Clause 1 of the BIT lays down two requirements. First, that the claimant must be owned or controlled by nationals of a third state. And second, that it must not have substantial business activity in the territory in which it is organized. In the instant case, if I may invite your attention to page 48 of the record, which contains Procedure Order 2 of this tribunal. And I read from paragraph 3, line 2 contained therein. If I may read with the tribunal, the shares of Attenborough Limited are currently held by Attenborough Group affiliates, which are all ultimately controlled by Attenborough and Company. Now, the claimant here is controlled by Attenborough and Company, which is domiciled in Reef, which is not either Mercuria or Bashira. And therefore, the first requirement of Article 2, Clause 1 is satisfied in this case. Moving to the second and the more contentious requirement of substantial business activities. Now, authors have noted that a company is said to have substantial business activity in a territory if it is involved in buying, selling, or contracting in that territory. In the instant case, members of the tribunal, the claimant is not involved in any sort of buying, selling, or contracting in the territory of Bashira where it is organized. While it does have a bank account and an office space, we submit that that is not sufficient for this tribunal to infer substantial business activities in the state of Bashir.
What authority do you have for that not being sufficient?
If first is the authors that I have cited, for instance, Stephen Yagush and Anthony Sinclair in their article.
Sorry, I'm more interested in cases.
Yes, Madam Arbitrator, the case, if I may rely on the case of AMTO versus Ukraine. In that case, Madam Arbitrator, it was noted while in that case a bank account and tax paying was considered to be sufficient. However, if I may distinguish that case as to how it is not applicable to this case, in that case, the claimant had in fact provided proof of the fact that it was paying income tax and that it was also paying value-added tax. However, in the instant case, in this record, we only know of the fact that it is complying with its tax obligations. We do not know whether it is actually paying tax or not. Compliance with tax obligation does not necessarily mean payment of taxes by the company. And secondly, in the case of AMTO, the company held a multi-currency bank account and provided to the tribunal proof of multiple transactions happening through that bank account.
Counsel, so is the issue here a lack of evidence? Should we stay these proceedings and order discovery? Can we do that?
Madam Arbitrator, while it is our submission that the burden to show that these requirements of substantial business activities are satisfied rests on the claimant, which it has not satisfied in the instant case, because we don't know what is happening in their bank account, what are they doing with their taxes, and merely having a couple of employees or an office space should not satisfy the requirement of substantial business activity. And if I may also use the case of AMTO to say one more thing, in that case, AMTO was organized in Latvia and was involved in a real estate project in Latvia, which means in that case it had entered into a purchase agreement with respect to a real estate property in the country of Latvia, which was an important consideration for the tribunal in determining that it had substantial business activity in Latvia. However, in our case, the claimant is not indulged in any such activity. All it is doing is controlling its portfolio of patents and some other business in South America and Africa.
So is it your submission that substantial business activity requires involvement with tangible property, and that intangible property would not qualify under any circumstances as a substantial business activity?
If I may clarify my submission, that is not my submission, Madam Arbitrator. What is required is that the activity or the property must have something to do with the territory in which the company is organized. In this case, all they are doing is with respect to South America and Africa, not with respect to the state of Bashira.
What about licensing to the state of Bashira or entities in the state of Bashira? Would that qualify as a substantial business activity?
Had that happened, Madam Arbitrator, that would have qualified. But in this case, the licensing and all has happened in Mercuria, not in Bashira. And therefore, it does not qualify as per the requirement in AMTO versus Ukraine itself, paragraph 68.
What about maintaining physical office space, having personnel, and performing other business activities?
Yes, Madam Arbitrator, as I said, and to reiterate that, first, maintaining an office space is not sufficient, or merely 2 employees of the character of a manager is not sufficient for this tribunal to infer substantial business activity. But even if it were to be sufficient for this tribunal, there is an essential requirement of it having to be in the contracting territory or in the organizing territory. In this case, all the employees and all are from are doing their business with respect to South America and Africa, not with respect to the state of Bashira. So as per the ruling, as per the requirement in AMTO versus Ukraine, that there is no substantial business activity, they are owned and controlled by foreign nationals, and therefore the substantive requirements of Article 2, Clause 1 are indeed satisfied.
So even though they're managing intellectual property, and they are physically located in Bashira, because it's intangible property that they are managing, you contend that that does not qualify as substantial business activity.
Our contention, Madam Arbitrator, is since that has nothing to do with Bashira, had the intellectual property had something to do with Bashira, as in the case of AMTO versus Ukraine, the real estate project had something to do with Latvia. The purchase agreement was in Latvia. But since that is not satisfied in this case, we submit that it shouldn't be. Even if they did have, those are mere 2 to 6 employees, which shouldn't be sufficient for this tribunal to infer requirement of substantial business activity. Now, if I may proceed.
How many employees would they need to have?
Well, there's not an exact number, Madam Arbitrator, but it should be the number of employees should be such that, we can infer that a multi-billion-dollar corporation, if we have to find out whether a multi-billion-dollar corporation has substantial business activity, I'm sure that the number would be much greater than 2 to 6, because it's such a big corporation. 2 to 6 employees cannot carry on substantial business activity on part of a multi-billion-dollar enterprise, Madam Arbitrator.
So a small business is not entitled to protection.
Madam Arbitrator, if I may.
A small business could not qualify as a substantial business activity?
No, Madam Arbitrator. The question is, can we infer that there is substantial business activity? The fact that it's a multi-billion-dollar enterprise employing 2 people in a particular territory having an office space shouldn't be sufficient for them to do so. If it were a small business, it would have been fine, Madam Arbitrator. Now, if I may move to my second issue, which deals with the arbitral award, that this tribunal lacks jurisdiction over claims arising in relation to the arbitral award. We submit that an arbitral award does not qualify as an investment in and of itself. This is because it does not satisfy the inherent criteria of the term investment, that is, of contribution, duration, risk, and contribution to economic development of the host state.
Counsel, don't you want to apply the lex specialis first?
Madam Arbitrator, while we have the BIT here, however, a mere mechanical application of the categories listed in the BIT would render absurd results to the extent that it would render ordinary commercial transactions also to be investment. So what we submit is that this tribunal should not merely rely on those categories, but along with that should also have some additional criteria to be applied, otherwise that distinction would be blurred. This concern has been recognized and used by several tribunals, such as the tribunal in Nova Scotia versus Venezuela and the tribunal in Romak versus Uzbekistan.
Even if you're right, wouldn't it be perhaps helpful, certainly be helpful to me if we started with the words of the treaty, because the treaty is what brings us here. And Article 1C talks about claims to money.
Yes.
Does that have any relevance in your view? Why are we not in the presence of a claim to money?
Madam, Mr. President, two-pronged answer to that. My first answer is that even if we were to merely rely on this term claim to money,
Well, I'm not saying merely rely. You're going to
Yes.
get to your second point later on, which
Yes.
is that the words are not enough. But if we start with the words, do you admit that the text of the treaty certainly gets us a long way toward jurisdiction?
if I may
Claims of
disagree
money.
and explain to you why, Mr.
Okay.
Arbitrator, it does not, because of the fact that in the first line, if I may just have a moment.
It
Yeah,
says
if-
any kind of asset held or invested either directly or indirectly, and it includes claims to money.
Mr. President, if you may not have read, you just
Yeah,
didn't
no,
read one
I'm-
important part, which is in the territory of the other contracting party. This arbitral award, Mr. President and members of the tribunal, has been obtained in Reef, not in Mercuria or Bashira. And therefore, this is an asset that they obtained in Reef and not in any of the contracting parties.
Where is it being enforced?
Madam Arbitrator, it is our submission whether while it is being enforced in the state of Mercuria, that should not be the territory in which the investment is obtained. The investment has been obtained in Reef, and therefore the territoriality requirement is not satisfied in this case. But even if the even if that were not to be the case, it is also one of the policy reasons why arbitral awards have not been considered as an investment in and of itself by several tribunals like GEA versus Ukraine, Chevron versus Ecuador, etc., is because it would create an alternative mechanism for enforcement of commercial arbitral awards and undermine jurisdiction of national courts. How would that happen, members of the tribunal? What parties would start doing is that they would have an arbitral award. Since they are not being able to enforce it in national courts, in a period of 2 to 3 years, 4 years, they will just come before an investment tribunal, ask them an equivalent amount in compensation, and undermine jurisdiction of the national courts.
Or the courts would just change tack and actually adjudicate disputes in under 7 years?
Yes, Madam Arbitrator, due to certain reasons which my colleague will be elaborating upon, we could not do so. But what I request this tribunal is to not create an alternative enforcement mechanism for commercial parties to easily come and enforce the award when they are not being able to do so in national courts because of public policy reasons or whatever other reasons there may be.
Sir, do you, without getting into the merits of your argument on policy, do you have any words in the treaty to which you would draw our attention? You've got 1 minute.
Yes.
What words in the treaty would you tell us to focus on if you wanted us to find in the treaty support for this policy argument of yours?
The words in the treaty, for not for the policy argument, Mr. Arbitrator, Mr. President, the policy argument is not based on the treaty. The policy argument has been based on a concern regarding the sanctity of the grounds in the New York Convention and the legitimacy of the national courts to be able to have jurisdiction over arbitral awards. In the BIT, we submit that it is since the territoriality requirement is not satisfied, therefore the BIT definition of investment is not satisfied by an
You
arbitral.
just mentioned the New York Convention. So are we creatures in any way of the New York Convention, this tribunal? Why should we care about the New York Convention?
Mr. Arbitrator, because the New York Convention is widely accepted, this tribunal should keep its sanctity in mind. Not only that, but that of national courts as well, Mr. President, because if this tribunal does grant saying that an arbitral award is I see I've run out of time. May I just answer your question?
Yes, please do.
If this tribunal were to do so and rule that an arbitral award is an investment in and of itself, it would create an alternative enforcement mechanism, thereby creating an easy route for them to undermine jurisdiction of national courts where they should actually go and enforce the arbitral award. This, we submit, should not be the policy that this tribunal should be laying down.
Thank you very much. I guess we're at the end of the 18 minutes. And if I'm correct now, the next speaker would be Ms. Svandova. Is that correct?
That is correct.
Thank you.
Mr. Presiding Arbitrator, distinguished members of the arbitral panel, good afternoon. My name is Helena Svandova, as mentioned by Mr. Presiding Arbitrator. This is my co-counsel, Nikola Klimova.
Good afternoon.
And together, we appear on behalf of Attenborough Limited, claimant in the present proceedings. Members of the tribunal, our client has been present in Bashira for 19 years, never once changing its seat. Throughout these 19 years, it has successfully cooperated with both Mercurian State and its National Health Authority. And the success of the partnership was celebrated by Mercurian chief governmental officials. Yet now, respondent seems to oversimplify the dispute when it presents our client as a mere mailbox company and the arbitral award deprived of the protection of the BIT.
Counsel, you said 19 years. Why is that relevant if, in fact, respondent is correct that your contacts are de minimis? Whether you have de minimis contact for 1 year or for 25 years, it would still be de minimis. Is that correct?
Mr. Arbitrator, it is relevant because throughout those years, respondent has cooperated with our client. Therefore, it is aware of its nature. And this will be part of my argument on the timeliness of the invocation of the denial of benefits clause.
Okay, but you will address the argument that the presence is de minimis, that it's
That
tiny.
is correct.
Yes,
I will
thank you.
address that point as well. So in my following submission, I will react to all of the submissions presented by the Counsel for Respondent in the same order. Firstly, I will establish that the invocation of the denial of benefits clause is deprived of any effect. And secondly, that this tribunal does have jurisdiction over the claims in relation to the award. So with regard to the denial of benefits, our submission is twofold. Firstly, that respondent failed to invoke the clause timely, and in any case, the invocation was not justified. With regard to the timeliness, the opposing counsel relied on Article 23 of the PCA rules, which sets the time limit for objections to jurisdiction. However, we need to make a distinction between objections to jurisdiction and between invocation of the denial of benefits, the actual act of the denial, as usually the circumstances giving rise to objections to jurisdiction arise prior to the initiation of the proceedings. And within the arbitral practice, there is no consensus on when should the exact time when the respondent states invoke the clause. However, if we look at all of those cases, and the Energy Charter Treaty cases say that the respondent state should do so prior to the claimant making the investment, whereas the United States BIT awards generally say that respondent is free to do so in the statement of defense. However, what those cases all have in common is reasonableness. What is reasonable to expect from the respondent's state? And that should be evaluated on case-by-case basis. And as I have already mentioned, respondent has dealt with our client for 18 years and was very well aware of its nature and of its presence in Bashir.
But counsel, if respondent always considered your client's engagement in its country to be commercial rather than an investment in nature, why would it have ever invoked or even thought to invoke the denial of benefits clause?
Madam Arbitrator, I agree with you that that would not be the reasonable case. So our submission is that respondent should have invoked the case at latest when it was notified by our client about the existence of the dispute and the intention to initiate the arbitral proceedings, which was on 20th September 2016, as you have previously pointed out. And that was exactly the moment when respondent should have invoked the clause.
And that was, you're saying that they should have invoked the clause several weeks earlier than they did, correct?
That is correct, Madam Arbitrator.
So how is your client actually prejudiced or harmed by the passage of a few weeks? I mean, is this a technicality that really has no significant impact?
Madam Arbitrator, I would firstly like to stress that the invocation was not justified, and I will get to this later. But
So is that the real issue? Is it the invocation rather than the timing?
the timing is relevant because there is a difference between use of rights and abuse of rights. And in this case, our client's notice of the dispute remained unanswered. So respondent waited for our client to incur costs getting ready for these proceedings, and only now is invoking the denial of benefits.
So should we just uphold the objection and then order them to reimburse you for legal costs?
No, Madam Arbitrator, because, as I have already said, and this brings me to my second limb of argumentation, the invocation of the denial of benefits was not justified. Now, we concede that our client is owned by nationals of a third state, but the conditions of Article 2 are cumulative. So the respondent was only entitled to deny the benefits to companies which have no substantial business activity in this case, Bashira. And our client, as I will demonstrate, does have substantial business activity there. The opposing counsel mentioned the case of EMTO versus Ukraine. And the case of EMTO interpreted the word substantial, which is also not interpreted in our BIT, and came to the conclusion that the word substantial means of substance rather than of magnitude. And so we submit here that the substantial business activity means that there's physical presence and that this physical presence relates to the core business of that company. And in our case, our client, there's no doubt that our client does have physical presence in Bashira. And the opposing counsel further went on to say that our client does not perform its principal dealings in Bashira. However, that is not correct. The principal dealings of our client are managing the portfolio of patents and long-term public-private partnership with developing countries.
What does managing a portfolio mean in practice?
Madam Arbitrator, our client holds about 50 patents in different developing countries. And Bashira, where it's seated, is not a developing country. So naturally, the managing of portfolio means that our client manages the production in the developing countries from Bashira. Now,
But the actual manufacturing is done in other countries.
that is correct, Madam Arbitrator, because there's no evidence of an epidemic of grayscale in Bashira. So that it would be very unreasonable for our client to have the manufacturing unit in Bashira when it can have it in developing countries where the treatment is most needed.
And where it's cheaper to manufacture.
That is also correct, Madam Arbitrator. So if I may provide you with an example. We had a company which was operating satellites. The core of that company's business would not even be on planet Earth. It would be in space. And that company would have 2 employees who would be operating those satellites. And those 2 employees would be changing shifts after 12 hours. Would we say that the company does not have substantial business activity on planet Earth? We would not. And this is exactly the present case. Our client in Bashira, our client has a patent lawyer, accountant, marketing, and those are all crucial for the functioning of our client's business. Because how would our client know how much to manufacture if it did not have an accountant? How would our client be able to keep up with the regulations in different countries if it did not have a patent lawyer? So although there are only 2 to 6 employees, they're absolutely crucial for the principal dealings of our client. And that is exactly the reason why the substantial business activity in Bashira is established in the present case.
If I could go back to your earlier contention that what matters is not the magnitude. You said substance, not magnitude. Is there any limit to that approach? I mean, if you had a person who was working 1/4 time or half time, would you still take that position?
Mr. Arbitrator, possibly not. However, in the present case, our client is both physically present there and has all of the important managerial posts performed in Bashira.
Okay, so there has to be some magnitude, you would admit. Is that correct?
A magnitude of substance, if I may put it this way.
Well, but you said substance was different from magnitude.
That is correct.
Right.
So substantial business activity does not mean large. It means of substance. So of substance of the principal dealings, which is the case in the present case, because the substance of our client's business are the patents. And our client does have a patent in Bashira. It does hold a patent in Bashira, only there's no epidemic, so it doesn't need to exercise it. And that was also actually, the opposing counsel mentioned the case of AMTO and said that AMTO engaged in developing projects in Latvia. However, that was only the submission of the claimant in those proceedings. And there was no evidence that that project would actually be realized. And that's the case at hand in the present proceedings as well. Our client does have a patent in Bashira. There's just no need to exercise the rights stemming from the patent. So if there are no further questions, I would like to politely invite this tribunal to rule that respondent's invocation of the denial of benefits clause is deprived of any effect. With regard to the arbitral award obtained by our client, it is not our submission that the award as such would constitute an investment. However, constantly developing jurisprudence, most recently the White Industries versus India case, gave effect to the BIT protection to arbitral awards or judicial rulings if those embodied the rights and obligations from an investment.
So you agree that the award is not a claim to money?
Madam Arbitrator, the award is a claim to money.
So why is it not covered by the definition of investment?
Madam Arbitrator, there is the requirement of the territorial link, and the arbitral award was issued in the People's Republic of Reef. However, that is not relevant in the present case, because if I may direct your attention to page 33 of the record, the very last sentence of Article 1, we may find a sentence which was also present in the Chevron versus Ecuador case, and which reads, quote, "Any change in the form of an investment does not affect its character as an investment." So we do not need to look at the award in separation, because it did not appear out of the blue. It is a metamorphosis of rights and obligations from the long-term agreement.
But those rights and obligations were already adjudicated in a commercial setting. How can we now allow the adjudication of those same rights in this setting as well?
Madam Arbitrator, I believe that you are now referring to the umbrella clause rather than the...
No, I mean the long-term agreement. The rights under the long-term agreement were adjudicated, and that's what metamorphed into the arbitral award. Is that right?
That is correct. However, so long as the rights from the long-term agreement qualify as an investment, the arbitral award embodies those rights and therefore deserves equal protection under the BIT.
So instead of going to commercial arbitration, you could have gone to an investor state tribunal to begin with, and we wouldn't be sitting here now.
Madam Arbitrator, if you mean for the breach of the LTA, that will be elaborated on by my co-counsel with regard to the umbrella clause present in Article 3, Paragraph 3 of the BIT. But what...
I finished answering my colleague's question, then I have another one.
But what we are dealing with here is whether the arbitral award that was fruitlessly enforced by our client is an protected investment. And completely in line with the, as I mentioned, the White Industries case, Chevron versus Ecuador, or Frontier Petroleum Services versus Czech Republic, rulings, as so long as they rule on an investment, are protected under the BIT.
What do you say to the respondent's argument about the New York Convention, that if we were to agree with you, we would somehow be undermining the 1958 New York Convention and opening the floodgates to the enforcement of commercial transactions through the investment treaty? What do you say to that?
Mr. Arbitrator, the enforcement proceedings took over 8 years and are still pending. So our client certainly does have a prima facie claim to denial of justice, which will also be addressed by my co-counsel. And therefore, for the stage of the jurisdictional objections, we do not see any reason why this should form grounds for rejection of jurisdiction in this regard. And
So is it the length of the time that you were trying to get it enforced that we should be concerned about? Because the respondent's argument is that if we agree with you, pretty soon everybody's going to be circumventing the New York Convention and coming to investor-state arbitration.
no, Mr. Arbitrator, not everybody, only those who have awards which are ruling fundamentally on an investment, which brings me to my argument that the long-term agreement between our client and Mercurian National Health Authority is an investment pursuant to Article 1 of the BIT. And as you have, Mr. Arbitrator, pointed out, the wording of the BIT does not leave any space for reading in other criteria. The opposing counsel attempted to firstly apply the Cellini test and then also mentioned the Romack versus Uzbekistan case. However, those tribunals went to search for the inherent meaning of an investment because the underlying treaty did not provide them with the definition of an investment. And in the Romack versus Uzbekistan case, the BIT read, and I quote, "An investment shall include," and then provided a list of different types of investment. So there was not a definition. It simply says investment shall include. Whereas in our case, the BIT clearly states that an investment means, and I stress means, any kind of asset.
Remind us, what was the investment in Uzbekistan?
Mr. Arbitrator, the investment in the Romack versus Uzbekistan case was a supply contract for wheat.
So it was a commercial transaction.
Yes, one could say so.
Okay, good. I think you've got 1 minute left.
I believe so too. So, Mr. Arbitrator and madams on the panel, I would respectfully like to invite you to assert jurisdiction over the claims in relation to the award, because the underlying contract fulfills the definition of Article 1 of the BIT. Thank you for your attention.
Thank you very much. Respondent, I think you have 1 minute for rebuttal.
Members of the tribunal, I have one short point of rebuttal. In the Romack versus Uzbekistan case, the tribunal faced an inclusive definition, an inclusive list of categories in the definition of investment. The tribunal noted that we must not simply rely on that inclusive list, which said investment includes XYZ, but should refer to the inherent criteria of contribution, risk, and contribution to economic development. In this case also, we find an inclusive definition which, as Mr. President himself read, includes X, Y, Z. We therefore need recourse to inherent features of the term, and since there is no contribution or risk undertaken by the claimant for the purpose of the LTA does not qualify as an investment but a mere commercial transaction. Thank you.
But the list that follows the word includes was preceded by the word means, and the claimants seem to be suggesting that we should give some effect to the verb means. What do you say to that?
Yes, Mr. President, and when it follows, what my submission is that includes has that list. So that list we should not merely consider. If you consider the word means and the terms that follow, it has to be an asset which is held or invested and further on in the territory. So this requirement of held or invested, from these requirements only, the criteria of contribution, duration, and risk have arisen, have been used by several tribunals like the Romack Tribunal. So therefore, the criteria are there in this definition itself, which uses the word means and uses then held or invested, etc., etc. Thank you.
Yes, I think now we have 1 minute from claimants.
Members of the tribunal, the BIT in the Romack case did not provide the words held or invested. And in our case, we have the word held, and the long-term agreement was certainly held by our client. So our submission is that the word means a conclusive definition. If the BIT provides that all apples shall mean oranges, then yes, for the purposes of the BIT, all apples shall indeed mean oranges. And this is what is binding on all of the parties and also on the tribunal. Thank you.
Thank you very much. At this point, we go to claimant speaker number 2, who would be Ms. Klimova, is that correct?
Yes,
Who will
that's
talk
correct.
about the merits.
Mr. Presiding Arbitrator, distinguished members of the panel. My name is Nicola Klimova, and I appear as the counsel for claimant on merits in the present proceedings. In 2004, the president of Mercuria made a public statement that, and I quote, Mercuria will do away with red tape and roll out the red carpet for investors. Although the respondent promised a majestic show, it is the claimant who's paying for it. In the following 20 minutes, I will demonstrate that the respondent first violated the fair and equitable treatment standard by frustrating claimant's legitimate expectations. Secondly, that the conduct of respondent's judiciary constitutes denial of justice in violation of the fair and equitable treatment standard. And thirdly, that the premature termination of the LTA constitutes violation of the umbrella clause in Article 3, Paragraph 3 of the BIT. Moving to my first submission, the respondent violated the fair and equitable treatment standard by frustrating claimant's legitimate expectations. In 2004, the Minister for Health emphasized the need for a stable and progressive IP regime, and also the need for protecting the IP rights. Yet 5 years later, these statements turned out to be only empty promises when the respondent abruptly changed its legislation and implemented the compulsory licenses which were applied in our present case. According to Article 3, Paragraph 2 of the BIT, the respondent is obliged to grant fair and equitable treatment to investments and consequently protect legitimate expectations of the investors.
Sorry, is it universally acknowledged that legitimate expectations form part of the fair and equitable treatment standard?
Madam Arbitrator, the legitimate expectations have been found as being one of the core principles protected under the fair and equitable treatment standard, as it was, for example, emphasized in the cases such as TechMed versus Mexico or Duke Energy versus Ecuador. So in all these cases, here we have unqualified fair and equitable treatment standard. And in those cases, the wording of those BITs was very similar, and also the legitimate expectations form the core of such standard.
But do legitimate expectations normally require a specific representation? And if so, is a political statement enough?
Madam Arbitrator, it is completely correct to say that for the assurances which I was quoting, the assurances made by the Minister for Health, there are two requirements that the tribunal should look at. The first is the specificity of such statements, and secondly, there is the timing. So if I may direct your attention to page 39 of the record, which is the statement of the Minister for Health. The Minister praises the partnership between the NHA and the pharmaceutical companies, specifically naming our client in paragraph 3. Now, the Minister even goes on and reaffirms the commitment of the state to empower and engage the right holders. Now, since our client being specifically mentioned in this statement, and also being one of the key right holders, the IP right holders, we submit that such statement is specific enough in order to derive the legitimate expectations for our client.
At the time those statements were made, was there a reasonable expectation that there would be a public health crisis?
Madam Arbitrator, it is true that the statement was made 6 years after the patent was obtained. However, what we need to look at is that the patent is only a right to be exercised, and the exercise of such right was the LTA, to which the respondent invited our client. And since The LTA as an investment, as my co-counsel already mentioned, was concluded only after the statements, these specific assurances were given to our client. These assurances were the moment when our client decided to participate in the public tender, to conclude the LTA, and to also begin the cooperation with the respondent.
I understand that, thank you. And perhaps I did not make myself clear. At the time that the statements were made, was there a reasonable expectation that there would be a public health crisis with the grayscale?
Madam Arbitrator, it is true that at the moment when those statements were made in 2004, the crisis was already ongoing, as the respondent might argue. However, we need to look at the conditions under the TRIPS agreement, which provides the respondent with the flexibilities, and our client does not dispute that. So, but if we look at the conditions in Article 31 of the TRIPS agreement, by which the respondent is bound, there is still the need first to try to negotiate on reasonable commercial terms with our client before the compulsory license is issued, and also to pay adequate remuneration to our client for the compulsory license. Now, if we look at the facts of the case, at the moment, or roughly at the moment when the compulsory license was issued, the grayscale was affecting less than 0.5% of the population. Now, this hardly constitutes a crisis for the respondent to claim, and in this regard, there should have been the consultations, and the respondent cannot invoke the exception to this rule. Now, coming to the question of the remuneration, the TRIPS agreement, Article 31, requires adequate remuneration to be paid. But if we look at the facts of the case, there was only 1% of the revenues of the, there was 1% of the revenues. However, the AG Pharma, being a generic drug manufacturer, has only little revenues as such in order to have for our client to pay the adequate remuneration. Now, even 1% as such does not constitute adequate remuneration with regard to the guidelines which are issued, for example, by the UNDP, or the guidelines which are issued by Canada, for example. And with regard to these guidelines, the adequate remuneration, the general one, is around 4%.
Can you just remind us, are you talking about net revenues or gross revenues? Or are they the same for you?
Mr. Presiding Arbitrator, we unfortunately are not sure from the facts of the case if the revenues are net or gross, so I'm afraid I cannot elaborate on this question.
Okay,
Right.
thank you.
Is the only thing we should look at in that the percentage?
No.
Let me make myself clear. The percentage gets applied to a revenue number, is that correct?
Yes.
And as the volumes went up, because the number of people affected by grayscale went up, didn't the volumes increase significantly? So that a lower percentage royalty is being multiplied by a higher revenue number, resulting in a large royalty? So my question is percentage the only thing we should look at? Or does the percentage, and what is a reasonable percentage, perhaps change as volumes change?
Madam Arbitrator, as I mentioned, the royalty was set up with regard to the income or the earnings of the AG Pharma. But since AG Pharma is a generic drug manufacturer which has only little profit, if any, with regard to the sales of the drug to which the compulsory license was issued. Now, here we come to the fact that even 1%, even though the sales might be very high, the percentage, 1%, is still well below the threshold which is required by the TRIPS agreement in Article 31.
Will you be getting to the umbrella clause shortly?
Yes, yeah.
Thank you.
I can elaborate on that right here if you
Okay.
prefer. Yes. Okay.
If you could focus, at least for me, it would be important to focus on the words entered into. That seems to imply an activity, something that is purposeful and something that has substance. What was the entering into that you're going to show us?
Mr. Presiding Arbitrator, indeed, the wording of the umbrella clause says that each contracting party shall observe any obligation entered into. And the wording entered into leads us to the legal source or the moment to which the attribution should be established. So entering into, with regard to the obligation, is the moment when the LTA was concluded.
But what was the entering into that you're going to show us?
Oh, so is the conclusion of the LTA, so the fact that the LTA, the conclusion of
The LTA itself, for you, the conclusion of the LTA. That's entering into.
Yes, entering into the obligation, which is with regard to the investment, is the LTA, because LTA as such is an investment, and it also relates to other investments of our client, which is the patent and the manufacturing unit, without which the LTA wouldn't be operating, and these activities form, the LTA as such forms the backbone of the investment activities of our client. So, since the LTA is the obligation entered into with regard to the investment, so entering into the LTA is the moment to which attribution should be established pursuant to the wording of the umbrella clause. Now, the legal source for attribution are the ILC articles, and more specifically, those are the articles, we rely on Articles 5 and Article 8. And to make it clear, only one test is sufficient to be met in order to establish attribution of the conduct of the NHA to the respondent. Now, if we look at the test under Article 5, it is a two-tier test which says that, firstly, the entity needs to exercise governmental authority, and secondly, that the very specific act in question, in this regard, the entering into the LTA, the conclusion of the LTA, is an exercise of governmental authority. Now, the NHA was set up to pursue the goal of universal health care, and in this regard, this very goal is enshrined in the Constitution of Mercuria. In this regard, so the goal, the performance of such goal is indeed the exercise of the governmental authority. So now we need to look at the very moment of the conclusion of the LTA, being the act of the actual exercise of the governmental authority. So if we look at the facts of the case, page 29, paragraph 7 of the record, we can see that the Minister of Health directed the NHA to estimate the requirements of the drug, to invite the investors, to invite pharmaceutical companies, and to enter into an LTA. And since there was the requirement of the state, the direction by the minister, such interference of the government is sufficient in order to establish that there was an act of governmental authority. However, even if that were not the case, there is still the control of the respondent over the NHA, and that is not only financial but also managerial. So, looking at the financial control, the NHA is financed by national taxation and some private contribution, but the national taxation is crucial, since in this regard, the NHA is financially dependent on the state. Now, coming to the managerial control, as I have already mentioned, the Ministry of Health directed the NHA to enter into the LTA. But it isn't only about the moment of entering into the LTA, it is also about the moment of terminating the LTA when the governmental interference was present. So, pursuant to the facts of the case, and on page 30, paragraph 16, shortly before the termination of the LTA, there was a meeting between the president of Mercuria, the Minister for Health, and the director of the NHA. And during this meeting, there were the discussions about budgetary issues, even with regard to public health. And this is precisely the reason why the LTA was terminated. It wasn't because of any contractual dispute, it was because of the budgetary issues, a very exercise of the governmental authority, and since there were the directions from the government, even the control of the government, the test for such control is established.
Council, do we have anything more specific than knowledge of a meeting having taken place about a budget? This doesn't seem very specific, and the actual termination happened 4 weeks later. That's quite a substantial amount of time if this was such an urgent budgetary issue.
Madam Arbitrator, in December 2006, so at the moment when the grayscale crisis in Mercuria was already on the top, the Minister for Health made clear and stated that the government would take every measure to secure the drugs for its population. So even from 2006, we have seen the intention of the government to interfere in the partnership between our client and the NHA, the entity with governmental authority. And in this regard, we sustain that there is substantial evidence to say that there was control and direction of the government to interfere in the LTA. So, moving to my last submission, which is the denial of justice. In 2009, the claimant initiated enforcement proceedings of an award which was rendered in its favor. However, 8 years later, we are here, the enforcement proceedings are still pending. The respondent is a party to the New York Convention, according to which it is required not only to recognize and enforce foreign awards, but also to do so in a reasonable amount of time. Now, what constitutes a reasonable amount of time and what is already the denial of justice? We invite the tribunal to apply an objective test. This means that the tribunal should look at the length of the proceedings, the behavior of the court, and the behavior of the parties as such. As I already mentioned, the proceedings last 8 years, and they are still in the first instance, and they haven't even got to the stage of merits. Now, the claimant initiated these proceedings in March 2009, and from the very beginning, it had to struggle with an aggressive obstruction tactics of the NHA and a highly lenient attitude of the court towards such breaches of the procedural law.
Counsel, is a breach of procedural law sufficient to amount to a denial of justice?
Madam Arbitrator, simple breach of procedural law is not sufficient, but if we look at the bigger picture, if we look at the whole enforcement proceedings and the overall attitude of the court towards the absence of the NHA, towards repeated requests for extensions which were not even necessary because the requests or the submissions of the NHA were supposed to be only short, we can establish that the denial of justice can be found with regard to the entirety of the enforcement proceedings.
But what is the standard? How do you define denial of justice? Is it a shocking and egregious conduct standard, or is it different because you're only claiming it as part of a fair and equitable treatment violation?
Madam Arbitrator, the denial of justice is indeed a high standard, which requires the conduct to be shocking. However, we submit that in this regard, since the behavior of the court was so lenient, and there was also suspicion about an unequal approach of the court to the parties in the enforcement proceedings, such conduct of judiciary is indeed shocking. So the NHA failed to appear in the court 9 times, and 9 times it also asked for extensions which were not necessary. Now, these breaches of procedural law or these requests led to 56 months of adjournments. And those 56 months of adjournments wouldn't have been necessary had the court administered justice in a proper way, had the court also issued more warnings and used the tools of the procedural law which it had at hand to decide the case and to speed up the proceedings.
We understand that you've got about 30 seconds left. Is that correct?
Yes.
What would you like to say to sum up?
Yes, I'm already concluding. So, respondent not only unlawfully terminated the LTA, but through its judiciary, it allowed the NHA, an entity with governmental authority, to abuse the enforcement proceedings. The conduct of the NHA is also attributable, and in this regard, we politely ask the tribunal to find that the respondent violated its obligations under Article 3 of the BIT. Thank you.
Thank you very much. Yes.
Counsel, sorry, before you finish, isn't there a risk of double recovery here if the enforcement proceeding now actually finds in your favor?
Madam Arbitrator, there would be a risk of double recovery. However, what we are asking the tribunal to do is to find to declare respondent liable for the conduct of the NHA for the breach of the umbrella clause in order to have the NHA and the respondent jointly and severally liable. Since if we want to enforce the award rendered by this tribunal, we would like to enforce the award in the countries where the respondent has its assets, since the NHA has only assets in Mercuria. So in this regard, the risk of double recovery is not present in the case.
Thank you. Is it Mr. Mehta who will now be speaking?
Yes.
Please go ahead.
Good morning, Mr. President, members of the tribunal. As introduced by my colleague, I am Aditya Mehta, and I will be representing the respondent in the remaining issues before this tribunal. Over the next 20 minutes, I will show that the respondent has not violated the investment treaty in passing the law 8458, in the conduct of its judiciary, and under the umbrella clause. And in doing so, I will mirror the structure for clarity of the claimant. Proceeding with the first members of the tribunal, the claimant states that we have violated their legitimate expectations, but we contend this on two grounds. Firstly, that no legitimate expectations arise in the present case, and secondly, that even if there are legitimate expectations, as was insinuated by Madam Arbitrator, they did not foresee a public health crisis, and in such circumstances, the respondent has a right to regulate its legal framework. Proceeding with the first, if I may take this tribunal to page 39 again. Madam Arbitrator, you had referred to the fact that any representations made by an entity must be specific and unambiguous to create legitimate expectations. This has in fact been recognized in various decisions, and they have stated that in cases such as MTD versus Chile, it has been required that any representation must refer to the investment in particular. On page 39, we see no reference to the long-term agreement as was indicated by the claimant to be the investment in this case. Thus, they can create no expectations with regard to the long-term agreement. If we look at the statement in particular, on the second sentence, it states, and I start at the end, a stable, progressive IPR regime is essential to such endeavors. Authors such as Professor Wadi, writing in the context of investment arbitration, have stated that compulsory licensing is an essential part of progressive intellectual property rights regimes in the 21st century, especially in developing countries facing disease. And since they were investing with regard to a critical disease that showed all the signs of becoming an epidemic, they cannot then state that they didn't expect measures such as compulsory licensing, especially because in their own claims, they rely on the TRIPS, and Article 31 of the TRIPS allows for compulsory licensing. But even if this tribunal were to believe that legitimate expectations existed, we argue that in light of the emergency faced by Mercuria, the state is entitled to take measures to combat such emergency. The standard the state must be held to, as was held in National Grid versus Argentina, is that the state did not act in an unreasonable or inequitable manner. Similarly, these arguments will also respond to the contentions of the claimant, where they say that under the TRIPS, there is an obligation to seek voluntary licensing before non-voluntary licensing, but the TRIPS recognizes that in emergencies, you need not seek voluntary licensing and can move straight to non-voluntary licensing.
Counsel, what is the TRIPS to this tribunal? Is it a law that we need to decide whether it was breached, or is it simply a fact that we have to take into account?
Madam Arbitrator, the claimant seems to rely on the TRIPS in creating legitimate expectations for themselves, while the TRIPS has its own dispute resolution mechanism, and thus this tribunal is not adjudicating a violation of the TRIPS per se. The claimant has based its expectations on the TRIPS, and thus we engage with them in that manner. In any case, as per investment law jurisprudence, this tribunal has the right to hold that the state has an inherent right to regulate its legal framework in an emergency, and the TRIPS would not bind this tribunal in this regard, which is why I'll move straight to showing that such an emergency existed in Mercuria. On page 43 of the record, we find that on page 42 of the record, my apologies, the fourth paragraph from the top, it says, a sharp increase in the number of confirmed cases of persons living with grayscale was observed from 20,485 in 2003 to a total of 266,298 cases as of 2006. That means the disease has increased almost tenfold in number in a small span of 3 years. If I may then take this tribunal to page 29 of the record.
And what is the total population in which those cases arose?
The total population, Mr. President, is 67 million.
67 million.
The claimant was correct in mentioning that as of 2006, less than 0.5% of the population of Mercuria suffered from grayscale. But what this tribunal should consider is not just the individuals who suffered from it, but how quickly this disease is spreading. Now, grayscale is a communicable disease, which means even if at this point only 500,000 to 55,000 people suffer from it, it has the potential to affect the entirety of Mercuria. And those statistics are as of 2006. On page 29, paragraph 15, the first line reads, as number of patients coming into care grew, the order value for Sanior doubled with each quarter in 2007, which means in every quarter in 2007, more and more people are needing to purchase treatment for grayscale. So the number of patients is increasing significantly.
Has respondent invoked a necessity defense here?
No, Madam Presiding Arbitrator. We are merely stating that with regard to the legitimate expectation claim of the claimant, tribunals have held that no claimant investing in a country legitimately expects that in the cases of crises, the laws of a country will remain stable. In this case, as there was a crisis, we are entitled to change our laws. The standard, these tribunals, and a lot of them are in the context of the Argentinian economic crisis, are whether we have acted unreasonably or inequitably.
But there has to be a limit, surely. If a state simply reverses their position entirely on a legislation, that has to be taken into account too. Isn't there a margin within which we can expect variation?
Madam Arbitrator, the question that was raised in a similar manner in the Saluka Investments case, and the answer the tribunal gave was the standard if the policy undertaken can show a reasonable relationship with the objective that is sought to be met. In this case, and since the claimant has relied on the TRIPS, I cite the Doha Declaration of the TRIPS, which explicitly states that states have the inherent right to decide the grounds for an emergency, which may warrant a requirement for non-voluntary licensing.
But counsel, my question is slightly different. What I'm asking is, for instance, if you take the Ecuadorian tax system that then raised taxes on crude exports, I think it was, 99% tax, that was considered too much. So where do we draw a line? I understand that there has to be a reasonable relationship, but that can't be it.
Madam Arbitrator, a twofold response to that. Firstly, we argue that the extent of the crisis, and I have shown the numbers, and the potential damage it does to the working age of Mercuria clearly satisfies the requirement in this case for non-voluntary licensing. If I may substantiate, non-voluntary licensing has been recognized, for instance, in cases of AIDS in Kenya, where it was still affecting a microscopic percentage of the population, but because of the potential AIDS had in the African countries, the World Bank, the WTO, and pharmaceutical companies eventually recognized that non-voluntary licensing was needed. But to another concern, which is that there must be some reasonability. My client has not provided the claimant with no remedy per se. He has given him compensation, which leads to the next submission of the claimant that 1% of compensation was not adequate in this case, because we understand the questions raised by Madam Arbitrator, and that's why we did give them a competitive rate of compensation. If I may take you...
What is your basis for stating that it was competitive?
Yes, Madam Arbitrator, if I may take you to the last page of the record, page 50. Paragraph 6 from the top, line 1590. In 2009-2010, royalty rates in Mercuria for drugs to treat incurable, non-fatal diseases ranged from 0.5% to 3% of revenue. Thus, the rate we've given them is well within the market range of what is considered just compensation in Mercuria.
So would 3% also have been just compensation?
Madam Arbitrator, the question is if it's competitive, and since we're within the range of what is given in these diseases, considering that we are a crisis-facing country and a developing economy, this tribunal should consider 1% to be reasonable given the circumstances.
Could you address claimant's response to my questions about reasonable compensation, in which they indicated that the percentage, the 1%, was being applied to a generic drug price and therefore resulted in a lower per unit compensation?
Madam Arbitrator, to respond to your question, the WHO has released guidelines with regard to providing compensation in cases of non-voluntary licensing. And in all these situations, the drug prices significantly are reduced after non-voluntary licensing takes place. Now, the claimant relied on Canada's method of granting compensation. Canada itself allows for compensation to be granted considering the circumstances of the country which is granting compensation. For instance, in their index, countries like Sierra Leone were allowed to provide as little as 0.4%, and developing countries like India were allowed to provide 1.2%. Given the circumstances the respondent is facing, where they're a developing economy dealing with a public health crisis and a healthcare budget that cannot cater to the needs of their population, 1% is well within the WHO's recognized compensation with regard to healthcare, and therefore this tribunal should consider it adequate in spite of the fact that drug price is reduced. Because the WHO, in showing those guidelines, was also aware that when compulsory licensing takes place, the reason for it taking place is that drugs should be available at a reduced price. Considering that, along with the fact that, as Madam Arbitrator herself insinuated, the volumes in this case will be incredibly high, this tribunal should not hesitate in considering that the claimant has received adequate remuneration. If that satisfies your question, Madam Arbitrator.
Mr. Mehta, you said a moment ago that legitimate expectations cannot withstand a crisis or an emergency. After the crisis has passed, when the emergency is gone, is there a duty to restore the equilibrium that existed prior to the crisis?
Mr. President, my apologies.
Yes.
In fact, the license that has been granted for grayscale by the High Court of Mercuria has been given only up till grayscale is a threat to the public health in Mercuria. The moment that the crisis, so to speak, has passed, this license will be taken away from the company, and since the claimant will be the only seller of Sanior in the market at that point, we argue that normalcy will be restored in those circumstances, and those expectations of the claimant will be satisfied.
Thank you.
Honorable members, I seek permission to move to the next issue in the sequence of the claimant, that is the umbrella clause. Now, Mr. President, you insinuated to the obligation that was entered into, but the BIT, Article 3, Clause 3, explicitly states, and I take you to page 34 of the record, each contracting party shall observe any obligation it may have entered into. The respondent in this case has not entered into any such obligation. Now, the claimant has contended that the National Health Authority's actions can be attributed to the respondent, but we contend this attribution on both grounds of Article 5 of the ILC articles as well as Article 8 of the ILC articles. Article 5 of the ILC articles requires two things. Firstly, that the entity is governmental in nature, and therefore the state can be held responsible, but also that that particular act of the entity had governmental action, what could be considered governmental in a contemporary setting, to quote the United Nations commentary on the ILC articles. In this case, the termination of the long-term agreement was a mere commercial contract and a decision taken by the National Health Authority.
Sorry, can you just respond specifically to opposing counsel's arguments regarding the direction to enter into the LTA and then the meeting that happened shortly before the termination?
Yes, moving to that, Madam Arbitrator, on page 29, paragraph 7, the first line. The line reads, acting on the recommendations in the report, the Ministry of Health directed the NHA to estimate the requirement in mercuria and invited offers from pharmaceutical companies. What this means is that it was the Ministry of Health that admittedly directed the NHA to estimate requirement and was the one that invited offers, not the National Health Authority. In fact, if I may take this tribunal to page 50 of the record.
Sorry, but isn't that exactly the point, that the Ministry of Health is undoubtedly part of the government?
Madam Arbitrator, while the Ministry of Health is, the National Health Authority was not directed to enter into the long-term agreement. The National Health Authority was directed to consider the requirement for grayscale.
No, sorry, it says here that the Ministry of Health directed the NHA.
To measure the National Health Authority and invited. The past tense use of invited matches the past tense in directed, which means that it was the Ministry of Health that was taking these actions and not the National Health Authority. The National Health Authority is the entity that entered into the long-term agreement. But if this tribunal is not satisfied by that fact, I take you to page 50, which has another fact that would support my contentions.
Could I just stop you there? Would the authority have taken any action contrary to the ministry?
If I may point out another fact on page 50 that would assert the answer to that, which is we would argue that while the authority may not have taken action contrary to the ministry, since the ministry does not control the actions of the authority cannot be the actions of the authority cannot be attributed to the ministry. All that claimant has relied upon in this case is that the funding is received from the government and the fact that in certain situations where the government gives directions, the authority complies. But in the United States versus Nicaragua case, although it was shown that all kinds of support, including funding and planning and other assistance was given by the United States to the entities in Nicaragua, the United States was not held responsible for their actions. The reason can be found on page 50 in the last line of the third paragraph, which explicitly states that there is no record of direct participation by Mercurian officials in the negotiation of the long-term agreement.
How was the NHA established? Was it pursuant to regulations issued by the government?
Madam Arbitrator, the NHA was established by, of course, the initiative taken by the government.
And did the United States government in the Nicaragua case create the Contras?
No, Madam Arbitrator. But just to take what was relevant in that case and we are trying to apply in this case, it is that what is required to be shown by the claimant and their burden is that the actions of the NHA in that particular instance were governmental because of the influence of the government. In this case, there's nothing to indicate that the termination of the long-term agreement involved governmental intervention. In fact, we have no authorities present in the case. We know per the first line of this paragraph that the NHA operates independently. I sense a concern, Madam Arbitrator.
No, finish your thought. I do have a question, but I want to let you finish.
And finally, members of the tribunal, that the NHA, that all the claimant has brought forth with regard to the termination is a meeting that took place 4 weeks before the termination of the contract. Now, not only, as Madam Arbitrator stated, is that a substantial period, but that meeting was concerned with budgetary concerns in general. And there is nothing on the record to indicate that that meeting had anything to do with the long-term agreement in particular. In these circumstances, international law would not want this tribunal to hold a government responsible for the actions of an independent authority given the circumstances. If I may now take your question.
Thank you. I'd like to clarify the roles of the various entities or parties or bodies that we're talking about. The compulsory license. The licensee the patent owner.
Yes.
Excuse me, licensor, the patent owner, claimant. The licensee, the one that's paying the royalties, is what entity?
It is a company called HG Pharma, which applied to the High Court.
All right. The imposition of the terms of a compulsory license was done by what
The-
entity?
High Court of Mercuria.
All right. And you have argued here that justification for imposing a compulsory license was because of a public health crisis,
Yes.
correct? Whose public health crisis?
It is a public health crisis faced by the people of the respondent state.
All right. And the government of Mercuria represents those people, correct?
Yes, madam.
What is the NHA's role as relates to that public health crisis?
Yes. Madam Arbitrator, the NHA is concerned with the distribution of medicines, and I understand what Madam Arbitrator seeks to imply here, but if I may contend the conclusion that thus the NHA is part of the government, an example in the commentary of the ILC articles, and I see that I'm in my final minute, if I may merely complete this answer. The example that establishes the standard for responsibility in the ILC articles is that if an entity, such as a railway service, is given sovereign powers to acquire land, but at the same time engages in commercial activities such as the selling of tickets, so people could travel on that land, the selling of tickets would not be considered a governmental act, but the acquisition of land would. In this case, we suggest that this tribunal apply the same example as a test, where admittedly, when the National Health Authority is distributing medicines to the people of Mercuria, its actions are governmental in nature, but where it's purchasing these medicines through a commercial contract, which the claimant himself says is an investment and is entering into for a profit, and we enter into because we get a 25% discount, should not be considered a governmental act, especially when there is no evidence of governmental interference through its officials.
But it is the governmental entity that you suggest provides, in effect, the authority for imposing a compulsory license because of the health crisis, correct? So I'm having some difficulty reconciling what sounds to me like saying, well, we should sort of look past the distinctions of who's the contracting entity and the license versus the governmental body that exercises their authority to protect the citizens under the public health crisis and compulsory license rights, and the NHA structure, that on the one hand, I seem to be hearing we should look past all of that and just mush it all together, that being a technical term, mushing it together.
Yes.
On the one hand. But on the other hand, you want us to impose strict consideration of who the entities are by looking at NHA, as I understand it, you want us to conclude that the NHA, that the government is not bound by the actions of the NHA. So for that purpose, you want us to consider these separate entities, but for other purposes, we should just sort of ignore it.
Madam Arbitrator, if I may disagree, it is the claimant's contention that the NHA and the government of Mercuria and HG Pharma have acted in tandem to, say, pass a law for compulsory licensing and after that grant a license for Valvotite and just basically target their investment. Our contention is that there is a National Health Authority. They entered into an agreement, but yes, arguably at the general behest of the government of Mercuria, who after that participated in nothing. And the National Health Authority terminated the long-term agreement when it could no longer afford paying for the medicines of the claimant. It sought, the claimant took us to arbitration, and while this arbitration was pending, there was no cure for people suffering from grayscale, and so the government of Mercuria passed this law because they wanted to treat them. The National Health Authority continued with the arbitration and is in fact fighting a case in court, fighting the enforcement of that award. We at all times maintain that these are two independent entities, especially with regard to the long-term agreement in particular.
Which are two independent entities?
The government of Mercuria and the National Health Authority. It is the claimant that is trying to create this nexus in the minds of this tribunal and hold my client responsible for actions that it neither controlled nor actions that violated the bilateral investment treaty in general. And this tribunal should not fall into this nexus that the claimant is seeking to artificially create. I have run out of time. And
Okay, thank you very much. I think we're now up to the rebuttal moment. Claimant, 1 minute.
Members of the tribunal, the opposing counsel stated that once the grayscale crisis passes in the country, the compulsory license would be withdrawn and our client would be again the only producer of Voltavit and would be able again to use its investment patent in order to have the profits and to cover the research and development. However, what the opposing counsel forgot to mention is that the patents last only a limited amount of time, and in this regard, the patent would expire very soon in 2018. In this regard, once the compulsory license was imposed, when the population was affected by less than 0.5%, and when the respondent started even exporting the drug, the respondent in reality destroyed not only the market in Mercuria, but also all the other markets in the region. And since the patent will expire as such, our client will certainly not be able to regain the protection of the IP rights. Thank you.
Counsel, you returned to your figure of 0.5%, but what respondent suggests is that the rapidity with which the disease was spreading would soon make it far more than that percentage. What do you say to that?
Mr. Arbitrator, Mr. Presiding Arbitrator, the total amount of the population is still 67 million people. So we need to look at the real fact of the amount of population being affected. And even though the compulsory license still wasn't the only mean of how to protect the public health of the population, the respondent could have imposed, for example, price control, which has also been applied in other countries, for example, in Zambia, where price control was seen as other way how to lower down the prices for necessary drugs to protect the population. Thank you.
Thank you. Respondent?
Mr. President, the National Health Authority approached the claimant for a 40% discount, and they said that was too much. For them to now go on record and say that they'd be okay with a price control, which would of course be much higher than a 40% reduction in price, is for them to go back on their own stance taken earlier in this dispute. And secondly, the respondent cannot wait until a large percentage of its population is suffering from a communicable disease. It took actions that any state would, seeing an epidemic breaking out in its country. Thank you.
Thank you very much. Well, I think this concludes the presentations. Is that correct? And at this point, we're supposed to retire and talk about. The tribunal will retire and deliberate. Thank you very much.